Welcome back to Lost Us channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California, here in San Diego. I always encourage my viewers to comment on the videos. And in recent weeks, I had an individual give his scenario that happened to him a few years ago. Essentially, officers entered his backyard without his permission, trespassing, and they found marijuana plants. He was later prosecuted for those marijuana plants. Now, his attorney and the government argued that the officers found and seized the plants under the Plain View Doctrine. Now, of course, I don't know all the facts. It is often difficult for me to give a good assessment. But if we take the facts at the basics, I have to disagree with that assessment. I don't think the Plain View Doctrine allowed the officers to seize the plants and prosecute this individual. So in this video, we're going to focus on the Supreme Court case that defines Plain View Doctrine and gives us the elements that are needed in order for the government to rely on this exception to the warrant requirement. So let's go ahead and discuss the case, and hopefully it's instructive and helpful to you. In this video, we're discussing Horton versus California, a 1990 Supreme Court case dealing with Plain View Doctrine. Now, I already have a number of videos dealing with this exception to the warrant requirement. And today, we're going back to the basics. This is the Supreme Court case that defines and gives us the elements of the Plain View Doctrine. As always, we're first going to discuss the facts, and then we're going to talk about the law. So here's what happened. Edwin was a treasurer of San Jose Coin Club. He was robbed at gunpoint after returning home from the annual show. There were two masked men with machine gun and a stun gun. They entered his home into his garage, took him out of the car, put handcuffs on him, and took the jewelry. The officers had probable cause to search Horton's home for weapons and proceeds. After doing some investigation, there were some witnesses to the crime, including the neighbors. The warrant, however, gave permission to the officers only to search for proceeds, including 3 specific rings. Notice, they had probable cause to believe that there would be weapons and proceeds in the home, but the warrant only gives them permission to search for the proceeds. When they enter the home and they're searching for these rings, they discover an Uzi, a revolver, 2 stun guns, handcuffs, and a brochure to the Coin Club annual show. Now, the evidence was seized under the Plain View Doctrine. The government argues that these items were all seized because the officers saw them in plain sight. But the defendant said the evidence was not discovered inadvertently, meaning when the cop testified on the stand, he said that he wasn't just looking for proceeds. He was in fact looking for anything connected to the crime. And so the defendant says, wait a second. If the warrant tells the cop only to look for proceeds, why is he searching for all these other items? So the defendant says that one of the elements of the Plain View Doctrine has to be that the items are found inadvertently, meaning that they're not being searched for. Otherwise, they should be in the warrant. So now let's talk about the law. Under the 4th Amendment, which protects you against unreasonable searches and seizures, the officers, generally speaking, need to have a warrant or an exception to the warrant requirement in order to enter your home and search for it and seize items from that home. Now, in this video, we're dealing with the Plain View Doctrine. The Plain View Doctrine was previously defined in Coolidge versus New Hampshire in 1971. Another Supreme Court case that you should probably read and be familiar with. But in this case, we're going back and we're looking at the elements. So here's what the Supreme Court says. Here are the elements. First, the officers cannot violate the Fourth Amendment in arriving at the place from which the evidence is being viewed in plain view, meaning that they cannot come to the home by violating the Fourth Amendment. The place from which they're looking at the evidence, that place, they have to be legally there, meaning they cannot enter by trespass. They have to have a warrant or some other exception to the warrant. So for example, in Coolidge, the exception was search incident to arrest. That's what the government was relying on, that they entered this home, and in that case it was really a driveway because they were seizing two vehicles. Well, in that case, the Supreme Court, and here, reminds us that the officers have to be at the place legally. The second element is the evidence not only has to be viewed in plain view, but the incriminating character has to be immediately apparent. Meaning, when the officers are looking at these items, by just looking at the item, you have to tell that these are criminal or immediately apparent incriminating evidence. Again, in Coolidge, when they were seizing the two vehicles, by looking at the vehicles, there was nothing apparently incriminating about them. Later on, when they were searching those vehicles, inside there was some gunpowder. But in the moment, there was nothing in plain view incriminating about the evidence. Hey, sorry for the interruption. Can you do me a huge favor? Can you click that like and subscribe button below? And then tell at least 2 friends about my channel. It will help me grow it. And finally, if you're at home and watching this channel without a t-shirt on, why don't you go on my website and buy one? And then later on, you can watch this channel and look cool. Thanks for watching. Now that I got your attention back after you subscribe to my channel, let's go back to the elements. So here's what we learned before the break. The officers need to have a lawful vantage point. Number 2, the incriminating character of the evidence has to be immediately apparent. And now we're on to the third element. The officers have to have a lawful right to access the object, meaning that if they're looking at this evidence from far away and they have a lawful right to be there, in order for them to seize that property, that also has to have a lawful right. They have to be able to access it. Here's an example. If the officers are observing evidence inside the home from the outside, if they can see it through the windows, they can either get a warrant or they have to have some exception to the warrant in order to go inside the home to seize that property. They cannot rely solely on the Plain View Doctrine in order to seize that property if it's far away. But in this example, under these facts, the officers did have a warrant to be inside the home. And once they were there, they were able to see incriminating evidence, including the guns, so they could seize them because they had a lawful right to access the objects, in this case, the guns. Finally, the defendant argues that there should be a fourth element, that the evidence is seized inadvertently, meaning that the officers simply stumbled upon the evidence. And in this case, they knew ahead of time that they were looking for the guns. And so the defendant says if they already knew that they were looking for the guns, the judge specifically said only look for proceeds. So here's what the Supreme Court says. The Supreme Court says that this fourth element is not needed because the scope of the warrant covers this fourth element. What do I mean by that? If the officers entered the home and found the rings, the scope of the warrant gave them permission only to look for proceeds. So that means in that moment, the search is over, and they cannot look through the home to find the guns. But if in the process of looking for the proceeds, including the 3 rings, they're finding this other evidence, including the firearms, they don't have to turn the blind eye and ignore the evidence that's clearly connected to the crime. They can, in fact, rely on the Plain View Doctrine without thinking or worrying that they found something that they, in fact, were looking for. If this video was helpful, if you now understand how the Plain View Doctrine works, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.